Welcome back to the Emily Show. Today, we're going to be talking about what in the world comes next for Karen Read and the Karen Read retrial. We had court on Monday. It was a very brief scheduling hearing. We're going to talk about that, the new dates, and what comes next. But we're also going to talk about what the jurors are saying. We now have a juror that has spoken to at least one member of the media who was present in court during the trial. We have jurors that have spoken directly to defense attorney Alan Jackson. We are going to talk about what the jurors are saying and how in the world this result is the result. So we're going to talk about what Karen Read is charged with, what exactly the defense is asking for, what those jury instructions are, what the lesser included charges are, and what the court said when she was charging the jury, what some of those words are, and how this jury got potentially confused. Because it generally seems to me that the jury is simply, or was simply, confused. And that is going to have some very real implications for Karen Read. Over on YouTube, I have broken down all of the motions. Today, I'm going to do a summary of them, and we're going to dive deeper into those counts, the instructions for those counts, and how we get to this result where jurors say they reached verdicts on two of the counts, but were hung on the other count, and what that means. So, are you ready to break it all down? There's been so many questions about this. So today, we are going to break it down. And Emily, where did you get all the questions about this? Well, we chatted about it on the live stream when we were watching the live court hearing, and all of y'all that were on the live stream were like, can we talk about this more? And so now it's the podcast. So thank you for being on the live stream and telling me this is what you wanted to talk about this week, because I wanted to talk about it too. So we should get into it. Welcome to the Emily Show. I'm Emily D. Baker, the internet's go-to legal analyst and big fan of the cursey words. I've been a licensed attorney for over 17 years. I'm a former prosecutor, and I break down the legal side of pop culture and entertainment stories we can't stop talking about. We should just get into it. Let's go. Thank you to today's sponsor, Factor. Sometimes we just need something to eat. We need it to be healthy, and we need it to be fast. I am always about making things easier for me, and I hope that the things I find easy are also easy for you. Factor has no prep, no fuss meals delivered directly to your door. They are fresh, never frozen, dietitian approved, and ready to eat in just about 2 minutes. So no matter how busy you are, you'll always have time for nutritious, great tasting meals. You can pick from over 35 different meals weekly, and you can add on breakfast options. They have dietitian-approved meals with a wide variety of ingredients like shrimp, blackened salmon, and filet mignon. And because there's different menus you can choose from, you can support your lifestyle, from balanced meals to maximizing protein intake to avoiding meat entirely. The choice is yours. So head to factormeals.com/EDB50 and use code EDB50 to get 50% off your first box plus 20% off your next month. That's code EDB50 at factormeals.com/EDB50 for 50% off your first box plus 20% off your next month while your subscription is active. Let's get back to today's episode. A road so far of how we got here, and there are other episodes covering the Karen Read case, but we are going to try to road so far where we are post-verdict. So the Karen Read trial went on for over 9 weeks, including jury selection. After days of deliberation, the jury came back with a note to the court, which we have replayed on live stream numerous times, but with a note to the court saying that they were deadlocked. That note said they were deadlocked as to charges. In the indictment, Karen Read is charged with 3 different counts. But as to count 2, there are also lesser included charges. Do I think a jury is going to parse their language between counts and charges? No. Do I think expecting a jury to parse their language between counts and charges? No. Do I think those words can and are often used synonymously? Yes. Is that where some of the confusion is here? 100%. So when the jury said they were unable to reach decision on the charges, there are 2 reasonable interpretations of what that means. One being they haven't come to verdicts. The other one being that they haven't come to verdicts on the lesser includeds of count 2 and some of the things. And since the jury was declared deadlocked and the court declared a mistrial, the defense has come forward with a motion to dismiss. The defense is asking to dismiss counts 1 and 3. What we're going to do first is pull up the indictment and go over what those counts are again, just as a refresher. And later we will be going into those lesser included counts. Remember, you don't see those in the indictment. Those lesser included counts are a function of law, meaning when you're charged with the count, not like 1, 2, I couldn't help myself. So when you get charged with count 2, those lesser includeds are part of the jury instruction, but it's not something that you'll see in the indictment. So what we are looking at right now is the indictment of Karen Reed from June 2022. This was after the grand jury when charges were enhanced to add this first count. So it gives the jurisdictional information and says, did assault and beat John O'Keefe with the intent to murder such person, and by such assault and battery did kill and murder the said John O'Keefe, and is guilty of murder in the second degree and not in the first degree in violation. And then they have the code section. Yes, this is their second degree murder indictment. Yes, when they read the jury instructions on this, they talked about the battery and assault with the vehicle. They talk about being hit with the vehicle. They talk about intent. That all goes to this count. This is count 1. As to count 2, Karen Reed, jurisdictional information, did operate a motor vehicle upon a way, and they describe this in the jury instructions as a public way or thoroughfare and define it at length, but a road. A way as defined in the code or in a place to which the public has a right of access, or upon a way or in a place to which members of the public have access as invitees or licensees, with a percentage by weight of alcohol in her blood of 8/100ths or greater, or while under the influence of intoxicating liquor, and did so operate said motor vehicle so that the lives and safety of the public might be endangered, and by such wanton and reckless conduct so described did cause the death of another person, to wit, John O'Keefe. So this is the operating under the influence. This has subparts, and then this has the lesser included. So this count has subparts to it, and that's why the jury instruction on count 2 got so confusing, and why there was argument over the verdict form, which we will look at a bit later too. There was argument over the verdict form and whether or not the verdict form was too confusing for the jury to figure out. Then we go to count 3. Count 3 has the jurisdictional information. Karen Reed did operate a motor vehicle upon a way or in a place to which the public has a right of access, or upon a way or in a place to which members of the public access as invitees or licensees, and without stopping and making known her name, residence, and the registration number of her motor vehicle, did go away to avoid prosecution or evade apprehension after knowingly colliding with or otherwise causing injury to John O'Keefe, such injuries having resulted in the death of said person. So all of this goes to whether or not she left the scene after hitting someone and that caused death. This is the hit and run causing death. So in the defense's motion, they are arguing counts 1 and 2 should be gone. Here's what you might notice about counts 1 and 2. They require an intent that Karen Reed knows that she hit John O'Keefe with the car, and in count 1, intended to hit John O'Keefe with the car. In count 2, it's hit him with the car and left. Both of those counts very squarely rest on, did Karen Reed hit John O'Keefe with the vehicle? And jurors have come forward since the mistrial and said that they were unanimous in finding her not guilty on those counts. And the defense is now arguing that the court must dismiss those counts to avoid an issue of double jeopardy, where Karen Reed is retried on counts where a jury came to a verdict. The Commonwealth is, of course, saying in those counts that no, we can retry her on counts 1, 2, and 3. You don't just get rid of 1 and 3, and you don't just get rid of 1 and 3 because the jury didn't, in fact, come to a verdict. The verdict forms weren't filled out. They did not say in their notes to the court, they did not say in any of their communications with the court that they had reached any verdicts. Of course, the court never asked if any verdicts had been reached. Of course, the court didn't ask if they had rendered verdicts on anything at all. And that is a further complication to this case because as to the defense motion, the law is very much not on their side. And that I have seen it as we've covered this more and more, that the feeling and the overriding feeling is, but if the jury intended to come to verdicts and in fact had verdicts, then why wouldn't the court just dismiss it? Well, I don't know if they can under the law as it stands. And I don't think they can based on what we have now. Because what we have now are out-of-court statements that are made to Alan Jackson, and Alan Jackson is relaying them to the court. So those aren't evidence of anything at this point in court. Do I disbelieve those statements? We've seen them from multiple individuals, and we've seen statements reiterated to at least one member of the media. Do we know if that's a same juror that spoke to Alan Jackson? No, we have no idea. We don't know. Could be somebody entirely different. No way to know that. But if the jury was confused and the court never gave them an opportunity to clarify it, it doesn't feel like the right result to retry Karen Read on counts 1 and 3. So when we're talking about what the jurors have said, I've gone through all the motions and you can find those and we'll link them down below too. But we also need to take a look at what a juror spoke up and said to a member of the media on Monday, July 22nd. And this is as they were going to court on July 22nd for the very brief scheduling hearing that we're going to just talk about in just a second. This is coming from Christina Rex on Twitter, and this is from July 22nd at 8:50 a.m. Central Time. So Christina Rex says, breaking, I just spoke with the deliberating juror from the Karen Read trial. The juror independently confirmed to me that the jury was unanimous for acquittal on charges 1 and 3, second-degree murder, and leaving the scene. This, again, is what the defense is asking be dismissed. The juror confirmed that the jury was hung on the lesser included charges under count 2 manslaughter. Their final vote was a soft, and that's in quotes, soft, 9-3 with 9 voting guilty. She goes on to say the jury considered being more specific in their notes to the judge, but were not clear on how they were supposed to communicate their unanimous decision on charges 1 and 3. So we need to talk about not only how could the jury be closer to guilt. 9-3 for guilt is a very retriable case from the perspective of the prosecution. So if you've got a 9-3 for guilt, you've gotten pretty close. And what is noticeable about count 2 and the lesser included is that the prosecution and the defense spent almost no time on that in closing arguments. They did not wrap up what those counts meant. They didn't talk about what was needed to find a verdict one way or the other on those counts. Count 2 was not discussed a lot, but count 2 and the lesser included are the under the influence, and that's what we're going to be mostly digging into today. Could the prosecution choose to dismiss counts 1 and 3 and just prosecute on count 2? Yeah, they can. The prosecution absolutely can dismiss on the counts that the jury has come back and said after the mistrial that they were going to acquit on. They can absolutely tailor down their prosecution, focus on the DUI, and focus on some of those lesser included, again, that we're going to talk about. Some of this confusion might be coming from the way the jury instructions are worded. A quick note about jury instruction. Jury instructions are formed by committees. Those are committees of lawyers. Generally, they also include conversations with judges. These are formed by committees. They are modified. They are updated. They are worked on. They are debated over. They are crafted and created. This is not the judge sitting down to write out the jury instructions. These are from the Massachusetts model jury instructions. There has been no argument at all that the judge read the jury instructions improperly. And if the judge reads the jury instructions improperly, it can be grounds for appeal. So will we see that in future filings? Perhaps. Have we seen that now? No, we haven't. Not at all. We have seen no argument that part of the reason the jury is confused is because the judge did something wrong with the jury instructions. So I know there are many that want to say, well, the judge did this. It seems that the judge, to me, is following what the jury instructions are in Massachusetts. And it may be that the jury instructions might be awkwardly worded and lead to confusion. And that is for Massachusetts to decide for itself, and that's for their jury instruction committee to decide for themselves whether or not they are going to change the way these charging instructions are worded. It is called charging the jury. You give them all of the rules, and then they also have it written out so they can read the jury instructions. This takes sometimes an hour or more. Going through the charging for count 2, Emily, did you go back and clock it? Yep. Going through the charging for just count 2 took almost 20 minutes of the judge reading the instructions because of count 2 and the lesser included and the definitions related to them. So this is not easily done, and then you have to reread them. So the confusion here is partly baked into the jury instructions, in my opinion, and the jury didn't know what they could and couldn't ask. And that's really hard too, because jurors don't want to do something wrong. 10 weeks, you've missed work for 10 weeks in the middle of the summer and sat in this tiny and apparently very hot courtroom where it was not always easy to hear. The judge was yelling at people to speak up all day long or threatening to turn off the air conditioning. This is not an easy thing to do. To not be able to render a verdict is clearly something the jury took very seriously, and not knowing how to communicate is something they seem frustrated by. But let's take a look at what the judge said as she was charging the jury with what they needed to do. As we get to the judge giving instructions, this is the judge giving the final charging instructions. She has already given all of the instructions. She's told the jury how they pick alternates and done all of that. This is as they are getting ready to go back into deliberate, as the judge is telling them exactly what they need to do as they get started.
Don't tell anyone, including me, how the jury stands numerically or otherwise on the questions before such time as you have reached a unanimous verdict.
Don't tell anyone, including me, where the jury stands. So we're going to listen to that one more time and let it play through. But she tells the jury, do not tell anyone where the vote stands until you've reached a unanimous verdict. That can make it very confusing if you're unable to reach a unanimous verdict. Couldn't it lead you to believe that you weren't supposed to disclose the split in your note or at all?
Don't tell anyone, including me, how the jury stands numerically or otherwise on the questions before such time as you have reached a unanimous verdict.
Before you reach a unanimous verdict. Do not tell anyone where you're split, including me, before you reach a unanimous verdict. And it says verdict. It doesn't say verdicts. Is it an awkward instruction? Yes. Do I see why the jury is confused? Yes. Can I understand why the jury didn't ask, what do we do if we have some verdicts or verdicts as to some count? I understand, but I've also seen juries come back with that exact same note. What do we do if we've reached some verdicts? And I've also regularly seen judges say, I received your note. You've said further deliberation is not helpful. Have you reached a verdict on any counts? And if the foreperson says no, then you're done. If the foreperson says yes, then it's very easy for the judge to say, okay, go back and fill in the verdict forms for the count or counts you have reached verdicts on, and then let us know. That's it. So the instructions are awkward. And I think this jury was trying to be incredibly mindful. And in doing that, the instructions didn't help them figure out what they needed. Also in these jury instructions, though, it says, if you have questions as to the law, you can ask me. Would a juror think, well, the jury instructions are confusing, is that the law, and ask the question? I don't know. But I think the jury tried to follow the instructions that were given here to the best of their ability with the information that they had. And I think the end of that instruction leaves room for confusion. The instructions are also written in a way that gives weight to reaching a unanimous verdict. You want jurors to believe and to know that they need to reach a verdict. Was there more the judge could have done before dismissing them? Yes. Also, none of the lawyers asked. No one asked that the jury be polled. But in subsequent motions, the defense has said, we didn't even have a chance to ask. And they were frustrated by that.
Remember that the decision of the jury must be unanimous, and the foreperson should be certain that each member of the jury is in complete agreement with the verdict. After the final vote of the jury, the foreperson should check the appropriate boxes as to each charge, then sign and date the verdict slips and notify the court officer that you have reached a unanimous verdict.
So again, the judge says, when you have reached a verdict, sign and date the verdict forms. But it does also say, as to all counts. So it can give both impressions, that you don't fill them out until you reach something on all counts, or as you come to a verdict on one count, do you fill it out? I still think it's confusing. But again, these are the model jury instructions in Massachusetts. I looked at the model jury instructions in Massachusetts. These are the model jury instructions. So the court's reading what the jury instructions are. And if this had been a problem more in Massachusetts, it already would have come up. So here we are. Let's take a look at what the potential confusion is with regard to count 2, as the defense is still asking for counts 1 and 3 to be dismissed. But first, I should probably tell you what happened at that scheduling hearing. Let's get to that. Scheduling hearing from Monday, July 22nd was about 5 minutes long, as they picked a date on the motion to dismiss for oral argument, and they picked a trial date. The court said very clearly when they were picking a date for oral argument, no matter what I do, this will probably go up on appeal. Yes, the defense can appeal the ruling. Yes, the prosecution can appeal the ruling, depending on what the judge does. Do I think the judge will rule after oral argument? No, I think the judge will take it under submission. Absolutely. So the judge has set August 9th as the date for the oral argument so that the attorneys can come in and further give argument on the motion to dismiss. That's the motion that we've seen. That's the motion that they've argued that the jurors either should be questioned, should file affidavits, or the court should just dismiss the counts, which I don't think they can do. I suspect we will not get a ruling on that day. I would be very surprised if we do. I think it will come in short order, though, because we are on a time clock now for the retrial of Karen Reed, and the defense is raising a constitutional argument that this violates her double jeopardy rights, and the prosecution is arguing that it absolutely does not, and they have the right to retry Karen Reed on all of the charges that they brought and can do so and will do so. So when the judge rules, we will see what happens from there. The trial date now is set for January 27th, 2025, which will be a winter trial for all of the discussion of the snow. And there will be some pretrial hearings and final trial conferences before then, but this case will go up to the appellate court. So with that, we're going to shift our focus to a discussion of count 2 and what those lesser included charges are and what that even means. First, let's take a look at the verdict slip, which is a verdict form where the jury can write their verdict on it by check yes or no, essentially. We're going to take a look at this. This is one that the defense argued over and said was unclear. The lesser includeds can be unclear. This logically makes sense to me. I think the hard part is the attorneys didn't take much time to go over this in closing at all. And that's normally when you tell the jury what you expect them to do and how to do it. There have absolutely been times where I have put verdict forms on the Elmo and told jurors how they work because they aren't always intuitive. So for the verdict slip for count 2, manslaughter while operating a motor vehicle under the influence, at first it says, in the above entitled case, we the jury say that the defendant is 1, not guilty, and it's got a line. 2, guilty of the offense as charged, manslaughter while operating a motor vehicle under the influence, and then it says check one or both of the following, and then it gives under the influence, and then it gives operating a motor vehicle with a blood alcohol above 0.08. In California, this would be your A count and your B count. Most jurisdictions, in fact, I can't think of one that doesn't do it this way, have either or. So you can prosecute somebody for being under the influence, and you generally have a field sobriety test and things like that to show somebody's operating under the influence, bad driving, etc. And if they don't take a test, don't complete a test, there's not a test on hand, they refuse, what have you, you can still prosecute them for DUI being under the influence, even if you don't have a test to show they're above the legal limit of 0.08. So there are two options there. And that's what's here. You have two options for the operating under the influence causing death. So that's why it is the manslaughter while operating under the influence. Number 3 says guilty of the lesser included offense, involuntary manslaughter. 4 says guilty of the lesser included charge of, which is interesting that it gives lesser included offense and then lesser included charge. So guilty of the offense charged, guilty of lesser included offense, guilty of lesser included charge of motor vehicle homicide, felony, OUI, liquor, and negligence. Check one or both of the following. And that is either motor vehicle homicide by operating a motor vehicle under the influence or motor vehicle homicide by operating a motor vehicle with a blood alcohol level of 0.08 or greater. So the jury has multiple options: not guilty, guilty of the offense charged, and then they need to pick A or B, guilty of the lesser included involuntary manslaughter, or guilty of the lesser included of motor vehicle homicide, and then A or B. Yes, this can be confusing, especially if they're not walked through it, because again, it took the judge over 20 minutes to read the jury instructions for all of these lesser includeds and the main charge. So the judge has to explain the main charge, the operating motor vehicle under the influence causing death, then the involuntary manslaughter, then the motor vehicle homicide. And we're going to go and take a look at what the charge and the lesser included charges are, because that is where the jury was stuck, and that is where the jury was coming back at 9-3. Can I see how a jury could come back with a guilty on some of these under the jury instructions? Let's talk about it. A huge thank you to today's sponsor, Honeylove. If you are still enjoying the social events of summer, it's time to consider Honeylove. Not only will you not be fussing with your undergarments, but you want to feel your best, especially if the weather is keeping you from feeling all the way your best. You know, when we get into August, it's just swampy. The Honeylove shapewear features lingerie-inspired design details that you will want to show off. So if you are using those as camisoles under a dress, it looks fantastic, or pair it with just a light and open shirt. Stunning. So from bras to the superpower short, you are handled. And because it's summer, you don't want to sleep on their cooling sleepwear. If you're ready to treat yourself to the best shapewear on the market and save 20% at Honeylove, head to honeylove.com/lawnerd. Use our exclusive link and get 20% off honeylove.com/lawnerd. And if they ask you how we found them, make sure to tell them it was the Emily Show. Let me know what you pick. Let's get back to today's episode. So this is coming from the Commonwealth's proposed jury instructions, but I also double checked them against the model jury instructions, and same. So that's where we're pulling these from. This is manslaughter while operating a motor vehicle under the influence of liquor. And I am reading directly from the jury instructions. This is what the court read to them in court. Am I going to try to zoom and shortcut some of that language to make it faster than 20 minutes? Yes, but we're going to go through it because it's needed. So, in order to prove manslaughter while operating a motor vehicle, the Commonwealth must prove the following 5 elements. First, defendant operated a motor vehicle, proven and admitted by the defense in multiple cross-examinations. Second, that she operated the motor vehicle upon a public way. Remember the prosecution showing all that video of like Karen Reed, or what they said was Karen Reed's car on the street driving past cameras? That gets you to a public way or place if you believe, or if the jury believes that's her vehicle with her driving. They are the finders of fact. They can make that conclusion. Third, while the defendant was operating the motor vehicle, she was under the influence of intoxicating liquor and or the percent of alcohol in the defendant's blood was 0.08 or greater. Was there testimony of this? Yes. Was there testimony that Karen Reed was drinking at a bar? Yes, a jury could find that. Was there testimony of statements Karen Reed made to the impact that she was under the influence when she was driving? Yes, there was testimony to that too. So if the jury believed that testimony, they could find that she was driving while under the influence. That doesn't negate what everybody else was doing in their vehicles, but we're just focused on this jury instruction and could the evidence support a jury coming to a finding on this count. Fourth, the defendant operated a vehicle wantonly or recklessly so as to create a high degree of likelihood that substantial harm will result to another. I think that's a more difficult count. Did we see any conversation about that? Well, if the jury believed what was testified to about her high rate of speed backing up, could they come to a conclusion on that count? Maybe. Could they determine that that was the wanton and reckless operating of a vehicle in front of 34 Fairview? Maybe. That is in evidence if they believed that evidence. I found that evidence to be fairly confusing. I thought there were a lot of reasonable questions as to that evidence, but the jury gets to decide that. And I can see where some on the jury might agree with that testimony. Fifth, that by such operation of the motor vehicle, the defendant caused the death of John O'Keefe. Is that a hard element as well? I think that it is, but we're going to get into the definitions here a bit. I am not going to define what a public way is, what it means to operate a motor vehicle, and what under the influence is. I think that these go by common definition and meaning. They are defined here more fully. Do we need them for our purposes? No. We're going to look at the fourth and fifth, and then we're going to go to those lesser includeds. The fourth element the Commonwealth must prove beyond a reasonable doubt, the jury instructions say, is that the defendant operated the vehicle wantonly or recklessly. A person drives recklessly when they ignore the fact that their manner of driving is very likely to result in death or serious injury to someone, or they are indifferent to whether someone is killed or seriously injured. It is not enough for the Commonwealth to prove that the defendant acted negligently, that is, acted in a way that a reasonably careful person would not. It must be shown that the defendant's actions went beyond mere negligence and amounted to recklessness. The defendant was reckless if she knew or should have known that such actions would pose grave risk of danger or death or serious injury to others, but chose nevertheless to run the risk and go ahead. The defendant must have intended her acts in the sense that they were not accidental, but it is not necessary that the defendant intended or foresaw the consequences of those acts as long as a reasonable person would know that they were so dangerous that death or serious injury could probably result. As such, the Commonwealth does not need to prove that the defendant intended to kill John O'Keefe. Rather, this is in the category of cases where public safety requires each driver, once they know what the situation is, to determine and to adhere to an objective standard of behavior. So there's a lot of ways the jury can get there. Can driving severely intoxicated count as this type of wantonness to a jury? Possibly. Can they determine that she was driving recklessly for the weather conditions? Possibly. There is room here for that, though I think that this jury was stuck on the lessers, not on this count, but let's continue on. It goes on to say, determining whether the defendant drove recklessly, you should take into account all of the facts of the situation: defendant's rate of speed, manner of operation, the defendant's physical condition, and how well the defendant could see or could control their vehicle, condition of the defendant's vehicle, what kind of road it was, or who else was on the road, what time of day, the weather and condition of the road, what other vehicles or pedestrians were doing, and any other factors, including the defendant's consumption of alcohol. So they're allowed to consider alcohol here as well. The jury instructions go on to say that the fifth element the Commonwealth must prove beyond a reasonable doubt is that the defendant by her actions caused the death of John O'Keefe. A defendant's act is the cause of death where the act in a natural and continuous sequence results in death and without which death would not have occurred. So does this leave open the possibility for the jury to discuss whether she hit him with a car or whether she left him at 34 Fairview in a state where he was intoxicated and could injure himself and fall in the snow and die of hypothermia, which was a factor of death here? So there is room to have the conversation beyond did she hit him with the car. Count 1, count 3 allows for no room for conversation other than Karen Reed hit John O'Keefe with a vehicle. Does this count allow for a broader conversation of that? Yes. Did any of the attorneys address what this means in their closing arguments? Not to my memory. Not at all. They did not talk about whether the defendant's acts were a natural and continuous sequence that resulted in death and without which death would not have occurred. Could you see jurors arguing that if Karen Reed hadn't left him there, he wouldn't have died when hypothermia is a factor and he's left in the snow? And we know from all of the testimony that she said she left him there. So that is part of the conversation here. We also know that his blood alcohol content was quite high. So she's not just left someone there, but she's left somebody who's intoxicated. So is there room to have that conversation? I think there is. Do I think this is what the jury was hung up on? Not necessarily. Let's look at what those lesser included crimes are. Lesser included offense of involuntary manslaughter. The offense of manslaughter while operating a motor vehicle under the influence of liquor includes the lesser offense of involuntary manslaughter. As a matter of law, the indictment that is before you, which charges the defendant with manslaughter while operating a motor vehicle under the influence of liquor, also charges her with that lesser included offense. The Commonwealth may prove the lesser included charge of involuntary manslaughter even if it fails to prove the greater charge of manslaughter while operating a motor vehicle under the influence. So it tells the jury, look, if you don't think it's manslaughter while operating a motor vehicle under the influence, then it could be involuntary manslaughter. What does that mean? To prove the defendant is guilty of involuntary manslaughter because of wanton or reckless conduct, the Commonwealth must prove the following elements beyond a reasonable doubt. First, that the defendant caused John O'Keefe's death. Second, that the defendant intended the conduct that caused the death. Third, the defendant's conduct was wanton or reckless. So as we get into these elements, that is what the jury has to find. Did the defendant cause his death? Was the conduct intended? And was that conduct wanton or reckless? First, a defendant's act is the cause of death where the act, in a natural and continuous sequence, results in death and without which death would not have occurred. Second, the defendant intended the conduct that caused the death. The Commonwealth is not required to prove that the defendant intended to cause death. So, on 1 and 2, what could a jury decide was the act? And could the jury decide that the act was intentional? Not that the act was intended to kill, but the act was intentional. Again, could a jury decide that dropping him off at the house is enough? And would they have had that conversation here? They might have. Third element, the defendant's conduct was wanton or reckless. Wanton or reckless conduct is conduct that creates a high degree of likelihood that substantial harm will result to another. Could you see jurors arguing over this element? I can. Is it conduct that creates a high degree of likelihood that substantial harm will result by dropping somebody off? Is that wanton or reckless conduct? If you factor in intoxication, does it change? So I wonder if this is where the conversation was on this count. But there's one other count that we're going to get to after this. It goes on to say that the wanton and reckless conduct is conduct involving a grave risk of harm to another that a person undertakes with indifference to or disregard of the consequences of such conduct. Does that fit what you saw in trial here? It goes on to say whether conduct is wanton or reckless depends either on what the defendant knew or how a reasonable person would have acted knowing what the defendant knew. If the defendant realized the grave risk, it says, created by her conduct, her subsequent act amounts to wanton or reckless conduct, whether or not a reasonable person would have realized the risk of grave danger, even if the defendant herself did not realize the grave risk of harm to another. So now the jury can say, right, but a reasonable person would have known, should have known. So even if the defendant herself did not realize the grave risk of harm to another, an act would constitute wanton or reckless conduct if a reasonable person, knowing what the defendant knew, would have realized the act posed a risk. And then it goes on to give the same negligent instruction that negligence is not enough. So could you get a jury stuck here on, but what would a reasonable person have known? Possibly. But this allows for conduct other than John O'Keefe being hit by the car. Let's go to the lesser included of motor vehicle homicide. And again, it gives the same instruction that the jury can find the defendant guilty of motor vehicle homicide without finding the greater charge. motor vehicle homicide, OUI liquor, and negligence. In order to prove the defendant guilty of motor vehicle homicide, the Commonwealth must prove, first, defendant operated a motor vehicle. Second, it was a public way or place. I'm truncating these a little. Third, while the defendant was operating a motor vehicle, she was under the influence of liquor or had above a 0.08 BAC. Fourth, while operating a motor vehicle, the defendant did so in a negligent manner so that lives or safety of the public might be endangered. Fifth, that by such operation of the motor vehicle, the defendant caused the death of John O'Keefe. So this changes the standard a bit from the greater charge with that fourth element that says that while operating a motor vehicle, the defendant did so in a negligent manner so that lives or safety of the public might be endangered. So this takes the standard and drops it down more. So the standard of conduct keeps going down as we go to the lesser included. It is why they are lesser. These have lower standards for the jury to find. So we're just going to talk about the fourth element here because the other elements, including the fifth element, are the same as in the others. But that fourth element shifts the standard to negligence. The jury instruction goes on and say elements 1, 2, 3, and 5 are the same as manslaughter. To prove the fourth element of motor vehicle homicide, the Commonwealth must prove beyond a reasonable doubt that the defendant drove negligently in a manner that might have endangered the lives or safety of other people. A person acts negligently when they fail to use due care. That is when they act in a way that a reasonable person would not act. This can happen either by doing something that a reasonable person would not do under the circumstances, or by failing to do something that a reasonable person would do. The defendant acted negligently if she drove in a way that a responsible person would not have, and by doing so created an unnecessary danger to other people, a danger that she could have avoided by driving more carefully. This still goes to the driving. It goes on to say the defendant's intent is not relevant in determining negligence. The Commonwealth is not required to prove the defendant intended to act negligently. The issue is whether or not the defendant drove as a reasonable person would have under the circumstances. In determining whether the defendant drove negligently in a manner that might have endangered the lives or safety of other people, you should take into account evidence, if any, about the defendant's rate of speed, manner of operation, the defendant's physical condition, how well she could control her vehicle, the condition of the vehicle, the kind of road, the weather, the road conditions, including the defendant's consumption of alcohol if you think they are relevant. So there are multiple ways on count 2 that a jury can find that Karen Reed could have acted in a way that led to the death of John O'Keefe. These aren't intentional, and not all of these predicate on her hitting him with the car and doing so intentionally. Counts 1 and 3 do. Count 3, you have to know you've hit somebody with the car and then choose to leave. Count 1, you have to intend to hit somebody with the car and then hit them with the car. Count 2 focuses on drinking, and if they determine that that was proven, then is different standards for the driving or the behavior that is part of the natural and probable sequence that resulted, or it says without which the death would not have occurred. So is there room on all of those to argue, or for a jury to argue, that there was a sequence of events here that without which John O'Keefe would not have died? There's room for them to argue that on the evidence they were presented, but it's still not easy, which is why I think we see a 9-3 split. It's not easy to come to, and it's going to depend on, I think, the backing up at the high rate of speed, whether the jury was convinced by that testimony or not. But this testimony allows for argument between jurors that Karen Reed's dropping John O'Keefe off or backing up could have led to a sequence of events. They get to determine the facts. The jury determines what the facts are. So if they determine John O'Keefe wasn't hit by the car, but that something happened that caused him to hit his head, and that something was Karen Reed backing her car up and him trying to get out of the way, Karen Reed leaving him there so that he could have slipped in the snow and hit a fire hydrant or whatever it is, could the jury determine those are the facts? They have the ability to do so, but they didn't do so conclusively. So I would be surprised. No, I'm not. I'm not going to say I would be surprised. I'm not surprised by anything at this point, but that's not true either. I'm constantly surprised, which also I should not be surprised by. But would it make sense for the prosecution to narrow down this prosecution to the operating under the influence? Yes. Do I think they're going to do that? No, I don't. I don't think they're going to do that. And I wonder if the confusion in the first case actually allowed the defense to focus on the larger count, the second-degree homicide, and not focus on this count, which allowed for confusion that maybe benefited the prosecution in this case. It's possible. So would it make sense to narrow this prosecution down? Probably. Would dismissing counts 1 and 3 give the prosecution room to maybe engender some goodwill amongst those that vote for the elected district attorney in Massachusetts? I don't know if that ship has sailed completely or not. Does it make sense to me to narrow this down if they choose to re-prosecute? Yes. Yes, it does. Do I think they'll do that? I don't know if they will. The statements that they made very quickly after trial is that they are 100% going after this prosecution full steam ahead. I don't think they should, but I think that they're going to. There's still a long time, though, between now and when this trial date is set, and a lot can happen there. So what we're going to see next and what this all means for Karen Read is at this point, the law that the defense is arguing is difficult. The judge choosing to dismiss counts 1 and 3 would absolutely result in an appeal by the prosecution. The judge choosing not to dismiss counts 1 and 3 or choosing not to allow the jurors to be heard from further is going to result in an appeal from the defense. Is it probable that we will see that appeal delay any potential start of a trial? Yes. Can that happen? I think that probably should happen. I don't think it would be equitable to retry her while this case is pending appeal. But there's still an outstanding FBI investigation.
The FBI!
There's still the issue of all of the disciplinary actions going on with Trooper Proctor, who has been suspended without pay while there are ongoing investigations into his behavior. There is still a lot circulating around this case and a long way to go. But for those of you that have asked, can Karen Read be retried? At this point, legally, yes. Can the jury be reconvened to issue a verdict? No. They have been dismissed. The court can take that information in, but legally, it's a very difficult road for the defense to even argue that the court should dismiss the case because of the constitutional protections. It is a legally very difficult argument, and courts tend not to upset the apple cart, as it were. The court choosing to dismiss this case would go against quite a lot of precedent, and that is unlikely with this judge. It is more likely that the judge chooses not to hear further from the jurors and says the mistrial has been declared, the case moves forward. It is up to the district attorney's office to decide. Could there be another result? There could be, but it would be the less likely result. But I'm always here to be surprised by the less likely result. Often, judges will pick the path of least resistance, CEG last week's podcast episode. That is what they do. Look, some of the best judicial advice out there, I think, comes from a friend who knew me when I was a very, very young DA. And that advice is don't be weird and don't do anything weird. Look, law is built on long-standing traditions, and when it needs to be modified, it is modified slowly and in increments. So don't be weird is probably the advice that this judge is going to adhere to. Dismissing these counts would be the weird result. So I don't think we will see a satisfying result to this, because when you have multiple jurors coming forward after spending 9-10 weeks of their life on this case, it can't feel like justice to them when the verdict that they say that they rendered was not heard by the court. And I think the prosecution's goal of due justice should override here. Because again, the court's goal is going to be, don't be weird. So it's up to the prosecution, I think, in this case, to do the right thing. And in that case, I hope that the judge does allow for some questioning of the jurors. I am just not confident in any way that that is going to happen or that it even legally can. Those are just my hopes, my internal. Emily, how do you feel about this? I would love to hear from the jurors more. Why? Because I think it gives the prosecution grounds to do the right thing. And I hope that we see that. It's unlikely that we will. Thank you to today's sponsor, OneSkin. OneSkin has incredibly easy skin solutions so that you are not dealing with a massive skincare routine. All of their products are created by scientists and backed by lab and clinical studies. Their OS1 peptide is scientifically proven to improve the biological age of skin at a cellular level. And OneSkin's OS1 powered sunscreens block UV rays while targeting UV-induced skin aging that you already have. And right now, they have a limited edition bundle of summer skincare essentials, which includes their daily moisturizers and broad spectrum sunscreens for the face and body. I wear sunscreen every day, not just on my face, but I make sure that I'm also covering up my colorful tattoos because sun will absolutely fade them, and I don't want that. OneSkin is more than skincare. It's about skin longevity, targeting the root causes of aging to help you look and feel your best at every age. Get started today with 15% off using code LAWNERD at oneskin.co. That's 15% off at oneskin.co with code LAWNERD. After purchase, they may ask where you heard about OneSkin and make sure to let them know that the Emily Show told you. It's time to expect more from your skincare routine, and you can invest in the health of your skin with OneSkin. Let's get back to today's episode. So with all of that, when you are a judge, you can adhere to the don't be weird advice. It's going to keep you out of the appellate court's ire. But for the rest of you law nerds, please live by the opposite motto of be all the weird and do all the weird, unless you're a judge, and then you have to be weird outside of work. So legal advice of don't be weird, very good for judges. Life advice, a la Steve Jobs, stay weird. Yes. Is that also like the motto of Austin, Texas? Probably. So for all of you, stay weird. And the judges can just be mad that they have to pick the path of least resistance and do the less weird thing. And with that, thank you for being here. I hope that cleared things up. If it made it clear as mud, I'm sorry. Hopefully the takeaway is that you can see where there's room for reasonable confusion here from the jury. Hopefully that can be rectified. Generally, the way these things get rectified is in future cases. Whenever the committee convenes and has conversations about these jury instructions, if this is a one-off, then maybe nothing will change. If this is coming up in courts across the state, maybe something will. So with all of that, law nerds, thank you for being here. Thank you for being weird. You're the best. May your Wi-Fi be strong. May the rest of your summer be delightful. May your toilet paper be plentiful. May the odds be ever in your favor. And may your family be well. Did I say it out of order? Yeah, you know why? We're gonna be weird. Because we get to. Isn't that a lovely thing? And so with that, law nerds, take care of yourselves. The world is a bit weird right now. And I'm glad you're here. I'm glad you're in the Law Nerd app. And I'm glad you're on the live streams as we break all this down. We've got a lot of court to come. We got a lot of hearings to come. And I owe you an updated docket. So stay tuned. That's coming. And with that, I will see you in the next one. You can stay up to date with everything I'm covering on our free iOS and Android app at lawnerdapp.com or search your app store for Law Nerd. And you can also follow me on social media at the Emily D. Baker. Remember, I stream on YouTube on Tuesdays and Thursdays. I recap all of that for you in quick bits on Monday. And of course, the Emily Show drops on Wednesdays. Thanks for being a Law Nerd.